Meseke'yi size takdim ediyorum. Kendisi kariyeri boyunca Federal Kriminal Polis Gücü Bilişim Suçları Dairesi'nde ve özel sektörde bilgi teknolojileri güvenlik danışmanı olarak dijital keşif ve adli bilişim hizmetleri veren şirketlerde kurucu ortak ve lider pozisyonlarında çalışmıştır. Şu anda EY Almanya'da sorumlu ortak olarak Central Zone Adli Teknoloji ve Keşif Hizmetleri liderliğini yapmaktadır. Ayrıca Almanya'da BT Güvenlik ve Adli Bilişim Bilirkişisi olarak da bilgi teknolojileri yani güvenlik ve adli bilişim bilirkişisi olarak da görev almaktadır. Bodo Meseke'nin burada olması bizler için bir şans. Fleming'de olduğu gibi Bodo'da da teknik tarafın bir duayenini görmüş oluyoruz. Kendisi bu konuların peşinden koşan, bu konuları kovalayan bir insan olarak zaten nam salmış vaziyette. Onun konuşmasını da dinledikten sonra uygun bulursanız soru cevap kısmını yapar, arkasından yemeğe geçeriz. Sabrınız için teşekkür ederim efendim.
So, thank you very much for the introduction, and thank you very much for having me here and giving me the opportunity to speak to you. As already introduced, I'm dealing with this issue as well, but I must say more from a technical side. And from the basics, I'm a technical guy, and for that, dealing with data, you always have to obey data protection rules and such. And so it is very common that we are talking about such issues, about new regulations and such. But I try to keep it a bit shorter as well, as there might be some overlaps with the speeches done before. But firstly, let me introduce you to a German law professor as an introduction who has influenced modern Turkish legislation. Is it working? No? Yes, okay. So this is the German law professor Ernst Eduard Hirsch is the founder of many laws in Turkey, which he created during the First Republic of Kemal Atatürk. So you see Turkish and German legislation might have several things in common. Ernst Eduard Hirsch is the father of modern Turkish legislation, so to say. And for example, the Stock Corporation Act, Universities Act, and Law of Intellectual Property. He was forced, unfortunately, to leave Germany in 1933 and became a professor at the University of Istanbul. And in Turkey, he gained his Turkish citizenship in the year 1943 and became professor at the University of Ankara. He never planned to go back to Germany, but friends and former colleagues convinced him to accept an appointment by the University of Berlin. Until his death, he kept his Turkish citizenship as a reminder at his most appreciated, beloved, and valuable time in Turkey. As you can see on the slide, his autobiography translated as a German law professor in the land of Atatürk. So it's very interesting to see already this relationship, and coming back to Fleming this morning, the first who started data protection law have been the Germans, and so there's influence over and over. But after this short introduction, I would like to move to the main topic, the impact of Directive 95/46 EC. So there are several impacts on business, and there have been impacts on German business for sure. And so I just want to flip through this. As this is only a directive, it does not have a direct impact on national legislation. It's different with the EU Union Treaty. So you need an adaptation to local law, what is currently done here and has been done in several other countries before, but this also leads to problems. There are differences amongst the several local laws, so you experience situations like now, can data easily be transferred between countries, yes or no? Even within the EU, there are differences in the realization of the laws regarding the EU directive. So therefore, but also to be able to bring this to local law, there's always a period of time given to fulfill this act, which has been most of the time 3 years. So if you don't bring this to a local law, for sure only as a EU member, you can face a penalty of the EU, but there have been no real severe consequences because of this for now. In Germany, we already heard it, the directive was implemented in May 2001. That was already also 5 years, and you can see that Germany isn't always the best pupil in class, but it most of the time wants to be. So, who are the main recipients of the directive? Okay. So, the main scope for sure is the focus of the personal data, and we have heard about this already a lot. And I just want to do some examples what can happen. So we already heard that personal data is described as any information relating to an identified or identifiable natural person. This is important, natural person. And this was already described by Fleming. And a natural person can be identified by several attributes. So, for example, number plates. Imagine when we had the toll collect issue in Germany, where we have wanted to have a fee for using the highways. Number plates have been collected. Number plates can easily be attributed to natural persons, and we will have a toll already also for German citizens in the future, and we need then data protection to be in place that this can't be misused. And also this is true for IP addresses. This was a very heavy impact when it was stated by court also that an IP address is to be seen as personal data. This had several consequences. The first and most important one was for law enforcement. Because as telecommunication providers, as a company, will no longer be allowed to store this information longer than needed, because it's now personal data. They have to delete it as soon as possible if it's no longer needed for technical purposes or something like that. Law enforcement was no longer able to approach telecommunication providers, ask whom of their customers used that IP address in a fraud or something like that, or some cybercrime. And so there was a longer time where German law enforcement was really lacking the ability to start an investigation in regards to cybercrime. There was, as I said, a period where we had some uncertainty in this case, and after that rules have been established how long it is allowed to store such information, what is the longest time that it is allowed and such, and we are still discussing this. This is a so-called Vorratsdatenspeicherung issue in Germany. Law enforcement still wants longer storage of such information, as it sometimes takes months until we get aware of cybercrime because it has been committed in cross-border, and we got an information after months, and then for sure the data is deleted. And for the companies, it meant how to renew their processes to no longer store this data, but how to deal with technical issues then. If this is a relevant data for you to find out if you have, for example, the attack, it was not an attack against telecom, but was always stated like this in the press. The issue that we had with this botnet testing for open ports on routers, and telecom was heavily involved in this. And they needed IP address information to get rid of this issue. So there is always a mixture, and it's always a balance that you have to find, that you deal with this correctly. So, and there's no difference between the data collection in Germany from private enterprises and local authorities. So this was also one of the declared goals of the directive, that any difference between the different collectors has been paved. That is very important. So government also has to take care of data protection, like any company has. Coming to the main principles. This is always lacking responsiveness here. Here we go. So the main principles, and I want to flip through this a bit more quickly than planned because we heard about this as well. Let me start with the transparency. Transparency is all about the act of the data collection itself. The controller, and this is always, we had already the definition of the different entities involved in data processing. The data controller has to be identified, and the purpose and the place of the storage needs to be crystal clear. Everyone has the right to know where the data is stored. This is complicated for cloud services. They sometimes even don't know themselves where the data is stored. There must be a legitimate purpose. Not every purpose is legitimate. So if you agree in sending your data to an e-commerce shop, it's for sure not legitimate to ask for your current mental status. And then we have proportionality. I guess you are all aware of this because this is a barrier in many legal constructs that have to be obeyed. So only do what you need to do with the data and do not exceed the allowed usage. But we for sure, this is fine for the EU states, but a lot of services are provided from cross-border, from Far East, from faraway states, where we have no legal access to, and where they might not have such rules that apply to data protection. So it's very important that everyone who provides his data knows where he provides it and to whom he provides it, to be sure that some rules are obeyed. So, and for sure, personal data is sold very, very often as part of the business. So after this very short introduction, I want to throw a spotlight on the influence on non-German business in a bit more detail. We heard already a lot, and the first thing that we heard was that there are different entities involved, and this is also valid and has an impact on our business, on EY's business. We do a lot of projects with clients where we get data and use this data and work with this data. And I try to avoid the wording where we process the data, because what we don't want to be is the data processor. This has several impacts. If you are named a data processor, at first this causes some conflicts with the German regulation around audit companies. You should always be a consultant and have some own abilities to deal with the data and judge how this data will be used. And for sure, if you are the data processor, you owe the data controller every right to double-check your environment. For sure, we have a very good environment, a very good data protection in place, but this is our intellectual property. It is our IP, how we set up our data processing unit for e-discoveries and something like that. And we don't want to have any company, every company, ordering or giving us the order to do an electronic discovery to join our data center and do an in-depth analysis of how we did it and if it fulfills data protection rules. We ensure it fulfills data protection rules, but we don't want everyone to be able to go in there. So, and this is something that you owe the data controller as being a data processor. The data controller has the right to do an audit to your data protection standards, to your IT infrastructure, if needed. So this is very, very important. And there are several other things that you can do as being a company to deal with this directive. And we have one very, very important thing that is different here. Usually laws work like everything is allowed unless it is forbidden. But in the case of this directive, it is vice versa. Every dealing with data, with personal data, is forbidden unless you have a good reason for it and it is allowed by law. And this was the reason why it took so long to bring this directive to life. And this has some severe consequences. For example, in the online business, every time someone orders something on the internet, he has to acknowledge that he is willing to provide his data, that he does by providing it, and that it might be processed and that it might be given to a third party. For example, ordering at Amazon not always means that Amazon is manufacturer and producer and deliverer of the products. They have to share your address with the delivery service. They have to share the address with the marketplace owner or whatever. So, and there you need, in some cases, you need the consent of the data subject, and so this has a lot of influence on the online business. There has been a study that came to the conclusion that they tested 120 very popular online services in Germany, and came to the conclusion that only 55% were compliant with the rules of the data protection laws. Some simply ignored the request to delete personal data if no longer needed. So this is very interesting, and for sure we have had a lot of discussions around safe harbor and privacy shield, because for American eyes these rules are simply exaggerated. For them, data means value, and everyone who is willing to give in information gets something back. This is the model Google is based on, and just remember the discussions around WhatsApp, Facebook, and such. They are all, if you use these services or Dropbox, you give them the right to access and to use the data you store there, no matter if it is a very important document and family picture or something like that. They have then the right to use it and to work with it. This is very, very important. And what was already mentioned before, as well by Fleming, as well as by Gürkaynak, was the necessity of having rules in place. This is very important, and every company in Germany really did it. We call it their Verfahrensbeschreibung. It's the rules of data processing, so to say. This is the first thing that a regulator will check. If you have an issue or get an assessment because someone complains you won't be compliant to the data protection rules, then the first thing the regulator does is checking your rules of data processing. So to have these in place, dealt with these carefully, checked it by a legal department is very, very, very important, and everyone, as I said, does so in Germany. So what can happen? I have a slide here, which is a brief description of a breach that happened some time ago at Vodafone Germany. Vodafone is a telecommunication provider, I assume a lot of you know. And so what happens when you break these laws? So the German Federal Data Protection Act punishes infringers with fines. It's quite low fines, to be honest. But gives also a direct claim for damages, and such a direct claim is what every company is afraid of. So when a breach happened at Vodafone, there was an employee of an external service provider broke into several IT systems of them and stole 2 million clients' data. They had to react according to the German Federal Data Protection Act, and this meant they had to inform every customer who was affected. So even to just send out letters, postal letters to 2 million clients costs around 1 million euros, just for the postal fee. And then they had to do newspaper advertisements, and this in newspapers that are more than regional, so they had to cover the whole Republic of the whole Germany with such an advertisement, and you can imagine how expensive this will be to have whole page advertisements or announcements in large newspapers. Beside all the IT investigation they had to do, the orders they had to fulfill from the regulators to check what went wrong, to make sure that the processes are right. Because, to be honest, you will never be able to avoid such thing. You can have the best processes. If you have someone who is able to access the data and he steals it, you can't do anything against it. Because this guy, for example, was an external service provider. They were intended to help them to run the business, and so they needed access to the data. So everything was okay, but they had to react in a manner compliant to the Data Protection Act, and so they have to do things like this. So this is then quite expensive, just to inform declines. Imagine Yahoo with 1 billion breached accounts would have been headquartered in Germany. Would have been expensive as well. So the next slide shows the difficulty that we have. We still have discussions about all this. And one side is heavily criticizing this German obsession with data privacy. I have a statement here from the Bitkom. The new regulations shall not limit the economic profits from personal data or avoid it completely. Bitkom is the largest association for digital economy in Germany. Their main critic is that, generally spoken, the German regulations prevent enterprises like a German Google, German Facebook, or other forms of social media to be able to rise up. So personal data is the new currency in Germany, will lose connections to the market. The other side says cybersecurity made in Germany has the potential to become a highly success for Germany if we are able to combine efficient systems, high security standards, and the protection of personal data. This is from the Fraunhofer Institute, an institute that is one of the largest privately funded research institutes in Germany and very well known for their studies. So you have both positions, but in the end, what lessons have we learned? I believe that data privacy didn't prevent Germany from becoming a huge provider. In fact, it is the largest market for the digital economy after the United States of America. So particularly because data is a new currency, a government needs to make sure these values aren't concentrated in the hands of a few. So my personal conclusion, it costed some money. It was a lot of effort in the beginning when our German business starts dealing with the general data, Data Protection Act, to bring all these processes in place, to have such rules, to find the right data protection officers, because having a data protection officer is a very, very good thing. This was some effort. But now, let's face it, we now are chosen very often as a provider for a service because of our data protection. Because people know, companies know, if they hand over data to a German company, it will be protected by the German federal data protection law, and this is a very strict law, and the data is secure. And you see the engagement of the EU to bring up other regulations. A lot of them are related to what already has been regulated in Germany. And I guess when it comes to digitalization, which is the new buzzword and the upcoming topic in the IT area, it will be very important to be able to ensure that data is protected. And so I guess the German business is in very good shape. We had a lot of projects with them in the past, in the beginning of this regulation, to bring this regulation to life for the companies. And I guess it really turned out. So what can you do to be as successful? Pseudonymization was already mentioned, and it is a very, very good thing to deal with personal data. If you can ensure that you have different databases and most of them are pseudonymized and are only attributable by additional measures, this ensures a quite high data protection standard, and you can easily bring this to life with the right IT environment. But you also have to face and think about what will be the next issues you have to deal with. For example, the right to be forgotten, so that data shall be deleted if no longer used, and that the data subject has the right that its data is deleted. There was a quite well-received court decision regarding Google in 2014, where Google was told to delete search hits from their results when these are linking to pages that have no longer accurate information, except press releases. So it was if someone has a private blog stating things about another person, and these stories are inaccurate, they have to be deleted in general, and Google shall no longer list these as a search hit. So this was an effort for Google to deal with this, and what did they do? They only suppressed these search hits in the result list in EU countries. So if you use google.com, you will still see the results because they are under another legislation. And for example, in Germany, you only will see a limited number of results, and it says in the footer of the Google side that the number of search hit might be limited due to EU legislation. And for sure, for other companies, this is as well a question. If you are having a company based in the EU, or maybe then with new Turkish regulation here, and someone tries to do a contract with you, this contract does not come in place, and then afterwards he said, no, I want you to delete everything that I have sent you as personal data because we don't have a contract in place. You should be prepared for this. And you should also obey for sure every other legislation. For example, in Germany, when I do start negotiating with a bank about a credit, I have to provide personal data, and then if we don't do the credit, they still have to store the data due to other legal rules, because this is part of the how to translate it. It's mentioned as a Handelsbrief, so it's an important business document that they have to store to be able to comply to regulators' rules. So there might be a lot of a lot of relations amongst different laws that are applicable. So, and what you also can do to prepare also for the future, and that is what I want to tell you about next, is the upcoming General Data Protection Regulation. You could work with binding corporate rules. These are rules regarding data protection based on European Commission standards, and these are accepted as being a guarantee for companies having the right level or adequate level of data protection if they have in place such formal, correct, binding corporate rules. This is really an important point. We have these as well to be able to, for example, transfer data within EY from Germany to the US and vice versa. So, and what we will see in the future is the next level is the General Data Protection Regulation. This regulation will become effective in May 2018, and it's called the Big Solution. This is quite well received, except one article. This is Article 31. Following this rule, enterprises or local authorities must report every breach and loss of private personal data. Even victims have to be informed. This is already part of the German, not the information of victims, but not the reporting, is already part of the German data protection law. And we will see some changes here. The main idea is to, what I said in the beginning, we have differences amongst the local laws based on the directive, but the General Data Protection Regulation will become EU law, and therefore it tries to do a harmonization amongst the EU countries to have the same, then really the same data protection level. And there are several things in there that you should be aware of. For example, there's then the obligation of having a data protection officer, and the fines are much higher. It's up to 4% of turnover, or 20 million euros. So this is really, really high. And again, imagine Yahoo would have been based in the EU, and we would have this general protection regulation in place. So that was my speech for now so far. And as I said, I flipped over some things as we heard about it before. I hope it was some sort of enlightening for you, and I'm happy to take questions now together with Ganesh.
Thank you.